by reason of the COVID-19 pandemic shall not be reckoned with in the computation of time for doing anything under the rules of court. Of course, you know that our rules provide that any process that would be undertaken by litigants has to be done within a time frame. And in order to ensure that litigants are not cheated out in the wake of the pandemic, wherein courts were unable to sit, this provision became necessary to ensure that the time lost is gained back. Paragraph 6 says that honorable judges and learned magistrates shall ensure strict observance and enforcement of the rules of physical distancing and the wearing of face masks by court staff, counsel, litigants, and all persons inside the courtroom and or within the precincts of the court. Of course, you know that this has been part of the guidelines given by the various advisors and the federal government of Nigeria, as well as the Honorable the Chief Justice of Nigeria, that apart from all other measures, there must be, people must observe physical distancing and then wear face masks. So this is a way of ensuring that within the court precincts and in the conduct of the affairs of the court, we observe those rules. Now, 7 says that every Nigerian group of, every litigant or group of litigants suing or being sued together in a cause or matter shall be represented by not more than one counsel in the courtroom, where the rules of legal profession or other exigency makes it imperative for counsel to appear with another counsel. Only one junior counsel shall be led in the cause or matter. Of course, we are aware that senior advocates appear in court with juniors. There's no limit to the number of juniors that ordinarily a senior counsel will appear with in the open court. But as a way of getting or managing this situation, the practice direction has limited the number of junior counsel a senior counsel would appear with to one. Of course, we know that this will affect the capacity of senior counsel to bring as many of his juniors to court to be able to observe court proceedings. But I would also realize that this is an unusual situation, and the practice direction is a process that has a very limited lifespan. We are trusting and hoping that we'll get over this period within a couple of weeks, and then we'll revert to some of those things that we have been doing. So it is not meant to exclude counsel or juniors who would appear in court and be exposed to advocacy and all other court processes. It is meant to enable us get across, and thereafter we will revert to our usual way of doing it in terms of the number of lawyers that can access the court. Now, 8 talks about in order to avoid a situation where traffic in and out of correctional centers, prisons, may catalyze the spread of COVID-19 to inmates hearing in criminal matters, including the production of defendants in custody, is hereby suspended until further notice. Other criminal matters, applications for bail or remand and overnight cases shall be entertained and determined by the court. Now, you would agree with me that part of the measures that has been put in place by the federal government is a restriction of movement of people from one state or one locations to the other. Now we have prisons in Suleja, which is in Niger State. We have prison in Nasarawa State, outside the shores of the Federal Capital Territory. We're likely to have logistic problems in having to send in people and out. Aside from that, I think this provision is meant to cater for the welfare and the health of the inmates. And so, taking for granted that this period will not last, it is being prepared or prescribed that remand orders be made for the prosecutorial agencies to keep suspects in their custody where bail is not granted. So that is the idea for that, provided that in paragraph A, it was provided that the court shall exercise necessary caution to ensure that as far as it is it's practicable, suspects are not ordered to be remanded in the correctional centers. The court should give due consideration to possibility of either granting bail. The court shall, in the case of non-bailable offenses or where it is in the interest of justice to grant the application, order that the suspect is remanded in the custody of the prosecutorial agency. Now, that is what I have explained. Now, 9 says causes and matters and other proceedings that can be determined on the basis of affidavit evidence may, as far as practicable, be had and disposed of by remote hearing on virtual platforms such as Zoom, Microsoft Teams, Skype, or other video platforms as may be approved by the Chief Judge. This includes cases initiated by originating summons or originating motion, application for enforcement of fundamental rights, and interlocutory motions, as well as adoption of written addresses and delivery of judgments through rulings. All participants in a remote hearing shall address properly for the court proceedings. Now, the express mention of one thing is the implied exclusion of all others that have not been mentioned. I mean, here we have given a list of the type of cases that that are amenable to this process as of now. They include applications, motions, and cases founded on originating summons, which would not require witnesses attending the court to give evidence. Now, the Honorable 10 says that the Honorable Chief Judge and learned magistrates should organize, the learned honorable judges rather, and the learned magistrates should organize their course list to ensure that not more than 5 cases are fixed per day. And in keeping with the demands of social distancing, the court shall indicate in advance the sequence and specific time for having cases on the course list in order to avoid convergence of counsel and parties in the courtroom. Now, the rationale for this is to ensure that the advisories on social distancing is strictly adhered to. What this means, therefore, is that a few participants will be allowed into the open court for the purpose of any particular hearing. And for example, if case A is to come up at 9 o'clock, it then means having regard to what the court, the judge sees and assesses of the case, can say the next case should come up at 11 o'clock. This is meant to ensure that at no point would the court be overcrowded. This is meant to protect the court users and the staff of the court. Of course, there could be an issue as to whether this would meet the requirement of public hearing, the fact that people would be unable to access the court. But I think that public hearing does not mean that a whole number of people must be present in the court. The fact that the proceeding is held in an environment that people know is not private, and they can also have access to documents that may issue out of such processes, makes it a public exercise. This, we must agree, is meant to ensure that we abide by the guidelines that have been given during the COVID period. Now, 11 said that judges and learned magistrates shall keep to the barest minimum number of staff clerks working with them in the courtroom. So it is a design meant to ensure that we have smooth running of the court during the period, and it is not meant to keep out any particular individual. Now, 12 says that in addition to observing social distancing and wearing of face masks, all court officials are advised to wash their hands regularly. Those are, some of the protocols that we should individually observe to ensure that we keep ourselves healthy and away from COVID-19. And lastly, there is paragraph 13 is highly very educative. It talks about the chief judge being able to review the practice direction and or issue further directives as prevailing circumstances may render expedient or necessary. So the practice direction does not pretend to have captured everything. This is meant to serve the circumstances we have found ourselves now. And as time progresses, if the Honorable Chief Judge deems it necessary to review or add or subtract from what we have now, I have no doubt in my mind that he will do that in the overall interest of administration of justice. I thank you for listening. Hello?
Thank you much,
Hello?
my Lord. Honorable Justice H.B. Yusuf.
Yeah.
Hello, my Lord, we can hear you.
Yes, are you
Thank
hearing me?
you very
Yes, I said hello.
Yes, my Lord. Thank you very much.
Hello?
Hello, my Lord, we can hear you, sir.
Yes, I said that in the course of interaction and presentation by our various participants, some of the issues that I've highlighted will be discussed upon for the purpose of fine-tuning and ensuring better understanding of the philosophy behind some of the provisions we have injected into the practice direction. Thank you.
Thank you very much, my Lord. Honorable Justice H.B. Yusuf, for your detailed presentation on the overview of the FCT COVID-19 practice direction. Thank you very much. Going forward, permit me to reiterate to the panelists most respectfully that each speaker has 10 minutes to speak to his question. Thank you very much as we abide by the rules. We're most grateful. Going forward, my next question is directed at my Lord Honorable Justice Peter Afen, who I understand.
So, right.
Who also happens to be a member of the ICT committee. My Lord, we would want to know the considerations of the committee when they drafted this, or when they proposed and drafted this practice directions. We want to specifically understand if the data privacy protection laws or issues and security were taken into account, particularly with regards to certain platforms that have been listed on our practice direction. My Lord, over to you, please, if you're listening.
Thank you very much.
My Lord, Honorable Justice Peter Afen.
Can you hear me?
Thank you, sir. Yes, my Lord, we can hear you, sir.
Okay, thank you very much. All of the protocols already established are duly observed, but of course, you know how I can't do without doing homage to whom homage is eminently due, and that's my Lord the Honorable Justice I.U. Bello, who's been the brain behind all of this venture. My Lord, my older brother, H.B. Yusuf, and chairman of the committee, and all of the participants and my learned friends. I like always to say that I am still your learned friend. My Lord, the chairman of the ICT committee, H.B. Yusuf, has run through what the practice directions are, and you have specifically asked me to talk about cyber security concerns and all of that. My quick response to that would be that those are concerns that we would have to grapple with. And of course, the platforms that we have listed, taking a cue from what the first presenter has said, is like a shift arrangement, you know, something that would keep us going so that we do not lag behind. whilst the entire world, moves on. So naturally, we cannot rule out all of the cybersecurity, hacking, cyber stalking, and other kinds of, malfeasance that takes place in the virtual world. I am told that I was reading, something not too long ago, and a firm of lawyers in England had to pull out from a hearing because the Zoom platform was hacked, and all of that, and they couldn't, as it were, vouch for the security of the documentation and the processes. But that's not a regular occurrence. It's not something that happens every now and again. And of course, I have noted in my note here that those cybersecurity concerns can only be fully addressed by the provision of specialized infrastructure, support infrastructure, specialized court platforms, that will support this virtual hearing. As it is now, we don't have that, and if it is COVID-19, which is ordinarily a bad thing, that provides the required impetus for us to be able to do what we should have done, for a long time now, then probably there is something good that has come out of a bad thing. Having said that, that shouldn't stop us from moving ahead, because of course, as you know, Lord Denning will tell you that if we do nothing, only on the ground that it has not been done before, then nothing will change. The entire world will move on whilst we remain static, and it will be bad both for us and for the law. Now, having said that, I only have to add that the practice directions themselves, as my Lord H.B. Yusuf pointed out, are never intended to be exhaustive. Of course, you look at the concluding clause that talks about the need, for modification, need for further directions that would come in place. So everything, especially the product of this kind of discussion, would only serve to enrich what we already have on the ground. And I would like to also just briefly say that practice directions by their nature are merely intended to augment, the existing rules. They are not standing on their own. Of course, there are concerns about why all the regular criminal cases, including especially matters in which inmates at the correctional centers have not been attended to and all of that. Of course, we cannot issue a practice direction that would go against the grain of the executive orders of the federal government. Of course, we cannot assure the safety of court users if we were to, serve as a conduit for catalyzing the infestation in the correctional centers. So those are some of the things that informed those restrictions. But as things ease up and we get used to this development, it is hoped that things will eventually pan out nicely. I thank you for giving me the opportunity to make this preliminary intervention. God bless you.
Thank you very much, my Lord. Honorable Justice P. We cannot remain static while the world moves forward. Forward, we'll take our third speaker this afternoon, who is Baba Asiwaju Adegboyega Awolomo, SAN. The learned senior advocate will be speaking on some of the very important provisions of the practice directions. We would like for him to concentrate basically on clause 5 and 6, and of course 9 and 10 of the practice directions, and also speak to the issues that he envisages will emanate from these provisions. Learned senior advocate, please, over to you, please.
My Lord, the Honorable Chief Judge of the FCT, Honorable Justice Ayubelo, the Chairman of the Planning Committee, the Chairman of the Nigerian Bar Association Unity Branch, the pace setters, my lords, my learned friends, distinguished listeners, let me say I appreciate the honor of being part of this historic session to discuss the very, very foundational practice direction of my Lord the CJ. Let me first of all commend my Lord the CJ for his initiative, for his vision, for his leadership quality that has reflected so much in the excellence, the practice of law by the bar and the bench in Abuja. I associate myself with all the good things said about you, and I wish you well. Now, the disruption imposed on the legal practice by COVID-19 has made migration into information communication technology inevitable. In fact, it was as if we were waiting for COVID-19 to get us to where we should be. In my view, it's my belief that technology, who had been our servant or servant of our wishes, has now become the master of our destiny through the distortions of our settled practice and traditional way of doing things. Some of us who are analog are struggling very hard to be able to keep with the movement of time and become what young men do. However, the practice of law, as we all know, is about effective gathering and deployment of information. So this ICT introduction will make us more productive, will make us less stressful and less expensive perhaps, but the end justify the means. I want to commend the thoroughness and practicability of the practice direction. I'm expected to speak particularly about the practicability of clauses 5, 6, 9, and 10. We have 2 10s. I say that the lockdown declared by the federal government has exposed us to so many disabilities that we suffer. It has also exposed us to what we can say the movement forward, where we ought to be. The use of ICT, many lawyers can't do more than text message. They don't know how to do emails. They don't know Facebook. They don't know any. But now we are forced to go or migrate into this, which is the modern level that we ought to be. Now, for the 6 weeks, the pandemic has created a lot of logjam, no filing, no payment of filing fees. Oh, many lawyers have gone to the extent that they are out of time, about 6 weeks actually, to file their processes. But the Honorable CJ, in his wisdom, has relaxed that disability. He has removed the burden that the lockdown has placed on us. Therefore, no lawyer will be penalized for filing his process out of time or for non-payment within time. Therefore, all sins are forgiven. So thank you, my Lord the CJ. That's kind generous of you. In fact, our clients are saying thank you because when you fail to file within time, you are made to pay penalty. You're also made to pay some extra costs. So these have been removed. Thank you, my Lord the CJ. Now, for the clause 6, it requires the wearing of face masks and enforcement of physical distancing. This is part of the protocols that is announced by the federal government and by the President Commander-in-Chief in his regulation. It has to be so. It cannot be business as usual anymore. And I can foresee from what I read in the papers and some other publications that COVID-19 is not to go in a month, in 2 months, or in 3 months. It will remain with us for a long time because there are many, many who are hiding or keeping the virus in their systems and have not matured. So we still need to keep ourselves safe. If we're allowed to get out of our homes to go to court, we must also recognize the need to preserve our lives and that of our clients. So I agree that physical distancing and wearing of face masks must be compelled or must be complied with. Yes, in Rule 7, you said every litigant or group using or being used together, cause or matter shall be represented by not more than one counsel. Yes. Yes. You also allow that a senior counsel, a senior advocate is allowed about one. Oh, I wish it were increased to 2, because sometimes you have one writing in handwriting, the other one using computer to record the proceedings. So if a senior advocate is enabled to have 2, it will be better for him, it will be neater for him, it will be more, the record is more reliable for him. Now, you see, another point is that it's imperative for counsel to be conscious of the need or understand and appreciate the thinking of my Lord the CJ in thinking in this Rule 17. It's not that people are being denied, but it's because people are being secured from danger. So it's very good, and I commend it. It's practicable, and I believe it should be entrenched. Now I'm more excited about Rule 9. I believe that Rule 9 ought to have been in place in the last 4 or 5 years when we started the front-loading system. I had a case in 2004 or something, or 5, in Federal High Court. Now in one of their divisions. We came to court. He said, Chief, I'm going to move your motion. I moved it. I said, in terms of as I wanted to go on elaborating. He said, you have elaborated in your submissions. You don't have to. It is not your argument here that will make me make up my mind or not make up my mind. I have read all your affidavits. I've read all your prayers. I have read all the attachments, and I know the case you are coming to present. And I sat down. The respondent wanted to go on a long, elaborate argument. She says, please, can you limit yourselves to what is there? If you have any case, you can cite it, I will consider it. 5 minutes after we have made our submissions, she went to chambers. 5 minutes later, she came out and read the ruling. Elaborate, rich, robust. What I'm trying to say is that it is not what you say in court, in moving your motion or your adoption of your addresses that makes the judge to make up his mind with respect to your case. The truth is that a judge is expected to understand your case, is expected to have read your submission, is expected to have formed his or her opinion. Where she has to use his or her discretion, he knows the law, because the law rests in the bosom of their lordship. So therefore, I'm thinking that this Rule 9 is most appropriate, and it should be for all times, not for COVID-19 session. It should be for all times. You go to court, you adopt, and you go. Thank God we have an opening now. This ICT has come to stay, and it should be there for many, many years, even after we are gone. So I'm hoping, I'm praying that the Honorable CJ will entrench this Rule 9 so that you don't need to come to court and waste the time of their lordships. Again, you go to Rule 10, and you talk about 5 cases, commendable, brilliant. These days, when I go to court and I see 20 cases on the list, I ask myself, how is the judge able to cope with 20 cases? Of course, I must say that our juniors suffer a lot these days. When they go, if their case is number 20 or number 19, and they have 33 cases on the list, he will have to wait all day. In Europe and some other countries, you are timed. You are given, your case will come at 12 noon. If you like, come at 12:05. You are the one who have changed yourself. Come at 2 o'clock. So the judge is able to manage his cases, manage his dockets in such a manner that it will give him peace, it gives him relaxation, it gives him all the benefits that he requires to think right. But when we clog the court with 20 cases, 15 cases, are we going to kill them? Are we killing them gently? Or are we helping them to do justice? That's why I believe that justice rushed is justice denied. Just like justice delayed, justice denied. So I commend Rule 9 and 10, and I want them to be on a permanent basis for everyone to comply with. I mean, I'm very excited about it, and I commend the thinkers who brought about these rules 9. For Rule 10, well, it's just like saying the same thing about counsel being allowed into the courtroom. It's the same protocol that we're talking about with respect to distancing and understanding the time that we are in. I believe that we can conveniently tell our clients, you don't need to be in court. If you want to be in court, we should also extend the possibility of these of the electronic system or ITC system to enable our client to connect with the court. I mean, there are arguments, because the courtroom is a public place, everything must be heard in court. No. If people who practice arbitration and alternative dispute resolution were used to all these remote court sitting, remote sitting, and it should be encouraging our courts. So therefore, in my conclusion, is that I commend my Lord the CJ and the planning committee or the technical committee for Rule 5, 6, 9, and 10. They are positive, they are progressive, they are productive, and we must clap for my Lord the CJ and the drafters of the draft direction. Thank you.
Thank you, Baba Siraju, for that detailed explanation of clauses 5, 6, 9, and 10. We are grateful. Distinguished participants, without further ado, let me proceed to our next speaker. He is no other than Dr. Alex Izion, SAN. He will be speaking on the doctrine of necessity as a justifiable reason for practice direction. And particularly, he will be highlighting the possible innovations that should have been concluded or should be included in the practice directions. Doctor, over to you, please.
Good afternoon.
Good afternoon, sir.
My Lord, the Chief Judge of the High Court of the FCT and the Chairman of the committee, my Lord, Honorable Justice H.B. Yusuf, and his brother George, my Lord Justice Peter Afen. May I adopt, so as to save my time, the protocol that has been outlined. I want to salute my brothers of the Inner Bar, Asiwaju, and other co-panelists and listeners. My topic is on the doctrine of necessity as justifiable reason for the practice direction. This is jurisprudential because you will permit me, allow me, I know it's within 10 minutes, but I will just speak to the issue. What may have informed this topic may not be more than the issue of the debate that the practice direction and the guideline from the Honorable CJN and the CJ it has some incursions into some constitutional provisions. And therefore, there's no way they can be practicalized without them being set aside later by way of an appeal. They have some of these provisions in mind. That's section 36, both of the Constitution or section 2661 of the Administration of Criminal Justice Act, where a defendant must be present in court except he misconduct himself, or if there are interlocutory applications to be argued. Aside that, the Constitution also provides that the defendant must be present in court, or section 266 of AJA that says the defendant will be docked. The issue jurisprudentially is, can you equate, streamline with physical presence, or let me not call it streamline now. Can you equate zooming or virtual sitting, where the accused or the defender is not physically present in court, physical? Zygnomatic nomenclature, that is physical present. This is the jurisprudential note that the people have, many of my colleagues, which they respect, they have a very valid point. And that until the National Assembly rectify this, some of these measures, because of certain positions of the Supreme Court, for example, delivering rulings in chambers or judgment in chambers, whether you cannot say that is a streamline of that or using the virtual proceeding. I just wanted to go to that background to show why these are fundamental issues. But with great respect, my view is that all these issues which have, I agree, settled positions by the Apex Court, Supreme Court on issues of fair hearing, that well, if it's held in chamber, it's not open court, it's a nullity, and all those, they are very solid. These cases were decided because of the peculiar circumstances they were. But we are in a peculiar situation. And that is why this doctrine of necessity becomes very, very imperative. This doctrine of necessity, you will discover that what is this doctrine of necessity? The meaning is that which is otherwise not lawful is made lawful by necessity. And that meaning was crafted by Henry Bracton, a medieval jurist, and was copied by Blackstone, another jurist. In 1969-70, we have the first shot of that by the Nigerian Supreme Court in Lacomi's case, which we're all familiar with. But before then, in 1954, the Supreme Court of Pakistan had opportunity of invoking the doctrine of necessity. And in that Pakistani case, that is the Federation of Pakistan and Moroccan, the Chief Justice of Pakistan, Honorable Justice Muhammad Munai, invoked this doctrine and proceeded to determine that matter in that manner. You may talk about the Lacomi case. The Lacomi came in later, which was 1969. The Pakistan case was 1954. Although that was not cited in Light Community case because I look at the cases decided, but they were all on all fours. Apart from that, in 1985, there is the Grenada case, the Supreme Court of Grenada. You remember that notorious case of the coup d'etat? And the issue was the issue of fair hearing, trying them on a law that was not in operation. And that was against fair hearing. The Supreme Court of the High Court of Grenada invoked the doctrine of necessity. Now, that's why my view is that with all before we wait for the National Assembly to help us to tidy up, I strongly believe that this is an era where we must abide by the practice direction and follow it. I said this with all signs of humility and respect because recently I was reading from one French journal. 4,798 persons have lost their life, officially confirmed to be judges, magistrates, and judicial officers in the worst hit area of Spain, Italy, UK, Iran, China, and the US. In fact, if I just let me just summarize some of those ones. You can see that number. The courtroom is a public area. There's no doubt about that. Lawyers are involved, judges are involved. Is issues alive that can talk about adjudication or prosecution or defense. In that article, Jordan, it was stated there that in Barcelona, the court, 60 persons lost their life during the court section. Why? Because the court divided from a lawyer who handled documents to other colleagues during the court section. In France, 3 judges and 2 prosecutors died, suspected to be infected by prison staff who brought in an infected man standing trial. Iran recorded the casualty of 97 judges and judicial staff. An investigation confirmed that they were infected through the use of lift, the escalator, and the handrail in the court building. In Milan, the defendant, Silvio, was accused of battery, an offense charged to court. He was infected in court because he sneezed 2 times. And all those people, other persons in the court caught the virus. Well, I don't want to go far, but this is to share you, if that is the case, is the living that can be a defense counsel, a prosecutor, or a judge. Do we then wait until the National Assembly amend this? We're talking about the issue of nullity, voidness, why there is no life. I think this doctrine of necessity is very imperative and reasonable. Any day, any time, anybody wants to challenge this, the fractions of fair hearing, like I've told you, and I've mentioned to you, all those cases, they dealt with even fair hearing. And the court were very, very emphatic on that. So I believe very strongly that this doctrine is justifiable if it can be invoked because I know there are bound to be litigation. Oh, you convicted me, sentenced me to death because I was not physically present because the Constitution says so. But we can rely on all this. And we don't know when this is going to end.
Sorry.
Yes. Yes. You have 2 minutes?
You have 1 more minute, sir.
All right.
1 more minute, sir.
On the issue of innovation, like my Lord rightly mentioned, as at now, this can be a working tool. We don't really need to, it can help us. But one of the issues I want to raise here as things that to bother my lords in looking at it is the issue of enforcement, compliance officer, separate from the provisions of the judges monitoring compliance. Yes, the judges and the magistrates will ensure according to Rule 6. But I would suggest that we should have a compliance unit who will now look at compliance from the gate, the premises, the registry, the library, the offices. Compliance is very, very important. If at the federal level and the state level we are still having difficulties, what about the court? I think that is one of the areas, but there are others, but maybe because of time. Thank you for indulging me for the time, and thank you for listening. I appreciate the opportunity, and thank you for considering me to share my little ignorance. I appreciate it. Thank you.
Thank you very much, Dr. SAN. We appreciate. We would, I am very certain we would afford you another opportunity to say some more. Because of our time, we would have to proceed immediately. This is particularly to our other speakers. Once you see the yellow flash background, it's time for you to begin to round off your presentation. Because once we have a red there, I may be obligated to stop you right there. I apologize deeply. Without further ado, may I proceed to the next speaker who will be speaking. There's been so much on the provisions of Section 36 of the Constitution. So he will be speaking to the provision of Section 36 sub 4, particularly, which talks about criminal trials within reasonable time, vis-a-vis clause 8 of the practice directions. And of course, taking into cognizance the provisions of AGJA with respect to speedy criminal trials. Distinguished participants, may I invite to the microphone Mr. Moses Alfred Ebute. Over to you, Mr. Ebute, sir.
Yes, can you hear me?
Yes, sir, we can hear you.
Okay, thank you. May I stand on the already established protocol so that I manage my time very well? Good afternoon, my lords, all of you put together. And good afternoon, senior advocates of Nigeria. I'm my co-panelist, Lukman Bolaji, and the entire host. Thank you for finding me worthy to be part of this discussion. My topic is on the provision of Section 36(4), sub 4, and paragraph 8 of the practice direction. Essentially, paragraph Section 36 of 4 of the Constitution provides that an unless the charge is withdrawn, while paragraph 8 is to the effect that inmates standing trial should not be brought to court and their cases suspended indefinitely, because the word further notice is used there. So without missing words, I am of the opinion that that section is in conflict and is inconsistent with the provision of Section 1, sub 3 of the Constitution. One will look at it again that in trying to give meaning to the term reasonable time as used in the Constitution, the AGJA was promulgated and several sections therein, beginning with Section 1, is meant to promote speedy dispensation of justice. In other words, with the promulgation of AGJA, delays in criminal trials became a thing of the past as far as practicable. Furthermore, if you look at Section 110 sub 4 of the same AGJA, a trial in magistrate court is supposed to commence latest within 30 days after taking of plea, and of course must be completed if where trial has commenced within 180 days after arraignment. These are all geared towards a speedy trial in criminal matters. And furthermore, you look at section 221 of same ACJA to prevent delay in criminal trials. Entertainment of preliminary objections have been forbidden. And at all, if it will be taken at all, then it must be considered and decision given at the judgment stage. And again, to also ensure that no more delays in criminal trials, section 306 forbids the entertainment of stay of proceedings. If you recall, for instance, the recent case of Ojizo Kalu that went to the Supreme Court, it started as far back as 2007 when he left office. It was preliminary objections and other things like this, applications like this that frustrated the case for 13 good years up to this present time. So it was because of this and such cases that the ACTA was promulgated to speed up trial of criminal cases. And again, if you look at section 396 of 3, it encourages and promotes, in fact, mandates day-to-day trial down to conclusion of criminal trials. So with this, it's crystal clear that delays are now thing of the past as far as criminal trial is concerned. And in section 396 of 4, it provides that each party, whether prosecution or defense, cannot be entitled to more than 5 adjournments. And even these 5 adjournments must be within, the interval must be just 14 working days. 14 working days for the entire 10 adjournments put together, or that's 5 for each party. And then at the exhaustion of these 5 adjournments in subsection 6, it becomes 7 days per adjournment. And this 7 is 7 working days. And then section 6 now makes it compulsory that where there's frivolous adjournments, costs ought to be awarded against the person responsible for the frivolous adjournments. And finally, under subsection 7, there's a provision mandating a judge, a high court judge who has been elected to Court of Appeal, to even come over with the fiat of the AG, I mean the chief judge, to conclude the trial if it's a part-hard matter. So when you look at all these provisions in ACJA, they are meant to speed up trial in criminal cases. But we now have a situation because of the pandemic we are going through, and we don't have an end in sight, where paragraph 8 of the direction has now suspended all trials, especially for inmates in correctional centers, ad infinitum, because there is no end in sight. To me, it is a moreover, even comparing the party direction with ACJA alone, it is a law that a party direction is inferior to an act of guide us. So if an act is superior, like ACJA is superior to any party direction, such as this one, then how much more the Constitution of the Federal Republic of Nigeria. So to cap it all, I am of the opinion that that section, the paragraph 8, is inconsistent, and if any litigation is taken upon it, it will be voided by the Superior Court. That's my contribution. Thank you.
Thank you very much, Mr. Moses Ebute, for your contributions on paragraph 8 of the practice direction. Distinguished participants, we are coming very close to the end of today's session. At this point, may I invite to the microphone for his presentation, Mr. Enenche Eleojo. He will be speaking on the procedural layout by the registry for the implementation of the FCT COVID-19 Practice Directions 2020. Over to you, Mr. Enenche.
Yeah, thank you very much, Mimi. May I especially acknowledge my Lord, the Chief Judge, and the other judges here present, learned senior advocates. Permit me, as every other speaker did, to stand on the already established protocols. I'm not sure I can do it better, even if I try. Well, we all appreciate the fact that we are going through rather very extraordinary times, and extraordinary times such as this has called for also very extraordinary measures. And I'm sure that for those of you who come around the courts now, you'll have noticed some
I wish that you are not sitting diagonally, sir.
Okay, sorry. I think
thank you, sir.
Yeah, I'm sorry, yeah. So like I was saying, we're going through very extraordinary times. And as you approach the court, you will notice that we have also adopted some extraordinary measures, and we just want to seek your indulgence. And some of the measures we have put in place here are only a reflection of the of various advisories we have received from the NJC, from the NCDC, and also from the Presidential Task Force on COVID-19. As you come into the court now, for instance, you will see that we have where we conduct our the legal years, usually the Gumi Square. You will see that we have some seats there. We have some seats there to prevent an influx of people coming into court at the same time. This is also as part of our measures to ensure physical social distancing of at least 6 feet or 6 feet or 2 meters between people coming into court. So you have to bear with us. If at any point in time we feel that there are already too many people, being admitted into court and carrying out business either in the court or in the registry, you may be asked to sit for a while and wait. So please, we hope that you will comply and help us in that respect. Furthermore, we now have a hygiene station outside, a hygiene station to ensure that you can wash your hands or sanitize before you come in. That is something we have been doing in the last 3 weeks. My Lord, the Chief Judge has shown very exemplary, has shown an example. Each time he comes in, he stops to wash. So we'll expect that everybody who comes in also will stop to wash before coming in. I mean, it's for your good, it's for our good, and the good of the system. Like one of the learned advocates said, I mean, it's a healthy man that can come into court to do business. And I mean, we are going through extraordinary times, so we hope you will do this also. If you do not want to wash, you can have your. If you don't want to wash, you can have your sanitizers, but we'll insist that you sanitize in the presence of our health officials, before they can admit you. Further to that, also, we have thermometers there. One of the indicators of an infected person, person infected with COVID-19, is the fact of that the person might exhibit fever. So to do that, I mean, to curtail that, we insist that your temperature, will be taken. If you exhibit high temperature, you may not be admitted into the court premises. High temperature, we're looking at something within the neighborhood of 38 and above. I had reports last week of someone who came and he was exhibiting a temperature of about 42.2, and he was denied entry. He tried to complain, but of course, he was denied entry, basically. So please, these are also some of the measures that have been put in place from the registry. You need to bear with us. By and large, the registry is open and ready for business. We may have experienced some challenges. You will not see as many staff. That also is to ensure that not too many people come into the court at the same time. But basically, you have staff here who will attend to your filing. We have commissioners of oaths on ground, to assess your documents, to deposit your documents. Also, the cashier unit is open, so you can also make payments and file, your processes. Furthermore, you will have noticed.
Mr. Elejo. Forgive us, our time is up.
I thought I had only taken 4 minutes out of my turn.
Forgive us, we have 10 minutes.
I thought
okay, one more minute, sir. One more minute.
Okay. Just quickly.
Yes, sir.
In line with the NJC's directive, you may notice some delay in processes you have filed. That is because the NJC has directed that all documents that are filed, should be quarantined for about 4 days, to ensure that if there's any traces of virus in it, it will take about 4 days for the lifespan of the virus to lapse. So if you notice any delay in your file processes, it could be as a result of that. And so again, we seek your indulgence, but on a case-by-case basis, depending on the urgency of matters that are filed may also be treated with dispatch. So that in a nutshell, are the measures put in by the registry, and we are ready to assist and help, as the need arises. Thank you very much.
Thank you very much, Mr. Elejo and Nenche. Thank you so much for arming us, with this information with regards to what to expect when we visit the registry at this time. Now, distinguished participants, you would notice that we are yet to take some of our very important panelists. We have a major highlights that will come at the end of this session. So before we do that, permit me to take the young lawyer in our midst, who will be speaking on the challenges that may be faced, by lawyers from the implementation of practice directions. Let me invite Mr. Lukman Bolaji to the microphone. Mr. Lukman, please.
Good afternoon, my Lord, the CJ of the FCTI Court, my Lord, Honorable Justice Peter Afen, my Lord, Honorable Justice MB Yusuf, London Senior Advocate of Nigeria, here present, senior members of the bar, and my fellow colleagues. I rely on the already established protocol. It is a great privilege for me, an honor, to have the opportunity to speak at this webinar. And without much ado, I'll go straight to the challenges that may be faced in the implementation of the practice direction released by my Lord, the Honorable CJ. The last speaker has mentioned some of the challenges. However, I'll further add some identified challenges. One of them is the fact that the practice direction is silent on the issue of the NJC guideline released on the 7th of May. But like the last speaker has said, there are measures put in place by the court to include the guidelines released by the NJC, which is commendable. I would also like to emphasize the provisions that relate to mitigating steps that the court should take if counsel and parties are filing processes at the registry. These mitigating steps are very key because they are aimed at protecting parties, counsel, and even the court officials. So I believe if the court is very strict on these mitigating steps, it will help the administration of justice and protect the lives of court goers. Another challenge that is identified is the issue of internet or the connectivity that may be faced. We all know that. As a matter of fact, it has even happened in this webinar where the secretary to the SGF now was unable to complete his presentation. So we will be faced with connectivity issue and the likes. Also, the provision of the practice direction, particularly paragraph 7 talks about limiting junior lawyers that would appear with maybe learned senior advocate and other senior member of the bar. I think this one is very limiting. It will deprive young lawyers the opportunity of learning from senior members of the bar. Another challenge is the issue of electronic filing. The NJC guidelines talks about the setting up of electronic filing. We know very well that we don't have that in the FCT here, but I would want to implore my Lord to try to consider that, because it will facilitate the process of filing court process during this period, so as to avoid the case of Barcelona incident that the learned Sikh, Mr. Alex Izian SAN referred to. Also, it is observed, I was in court last week, some of the junior staff of the court, they said they are yet to resume because there is an order by the head of service which says that it is only those that are level 14 that should resume. So we will have issue of shortage of manpower. I want to also plead with my Lord, the CJ, to look into that. Then also would likely have the issue of the availability of the gadgets for lawyers, particularly young lawyers. So the gadgets, we all know, may be very cost effective. So I believe the bar can help young lawyers to access these gadgets that would facilitate them or that will assist them in participating in the innovative that the practice direction is trying to set up. I think those are the little challenges I've been able to identify. Thank you for the opportunity.
Thank you very much, Mr. Bolaji, for giving us those challenges, that we're likely to face. Distinguished participants, ladies and gentlemen, we have come to the highlight of today's session. We have a debate from very two prominent members of our panel would be speaking to this afternoon. You would agree with me that the last 1 week, the social media has been agog with arguments for and against the validity of virtual hearing under our jurisprudence. This afternoon, we are going to engage two of our speakers who will be speaking for and against. And of course, we would employ my Lord, Honorable Justice Peter Afen, who would rule on their submissions thereafter. It is my singular honor to invite Mr. Kende Ogunwumiju, SAN, who will be speaking for the validity of virtual hearing under our jurisprudence, and Mr. J.S. Okutepa, SAN, who will be speaking against, the said topic. May I please invite Mr. Kende Ogunwumiju, SAN, to please take the microphone.
Thank you very much, Mimi. My lords, then colleagues of the inner and outer bar, distinguished participants, I thank you for this opportunity. And let me just go straight to my argument. The starting point of this argument, obviously, in support of the proposition that virtual proceedings are not unconstitutional and an amendment of the Constitution will be superfluous. I refer to Section 36 of Section 3 of the Constitution of the Federal Republic of Nigeria, 1999, as altered. Same reads, my lord, the proceedings of a court or the proceedings of any tribunal relating to the matters mentioned in subsection 1 of this section, including the announcement of the decisions of the court or tribunal, shall be held in public. In interpreting this provision of the Constitution, I submit.
I'm sorry, section what, sir? I didn't get you.
36 of section 3. Section 36 of section 3. In interpreting this provision of the Constitution, I submit that same ought to be construed broadly, unlike regular statutes. And Your Lordship, the reason for this submission was best explained by the Supreme Court itself in the decision of the Supreme Court in Obi and Mbakwe. Your Lordship, the decision is reported in 1984, 1 SC 246 at 257 to 259, lines 25 to 5. Sorry, my lord, 258 to 259. And this is what the Supreme Court said. The function of the Constitution is to establish a framework and principles of government, broad and general intended to apply to the varying conditions which the development of our several communities must involve, as being a plural dynamic society, and therefore mere technical rules or interpretation of statutes are to some extent inadmissible in a way as to defeat the principles of government enshrined in the Constitution. And where the question is whether the Constitution has used an expression in the wider or in the narrower sense, in my view, this court should, whenever possible, and in response to the demands of justice, lean to the broader interpretation, unless there is something in the text or in the rest of the Constitution to indicate that the narrower interpretation will best carry out the objects and purpose of the Constitution. I also rely on the more recent decision of the Supreme Court in Marwa and in Yako. The Lordship, that is reported in 2012 6 Nigeria Rookie Law Report, Part 1296, 199 at 291, paragraphs 8 to C. And this is what Mustafa CJN said. The Lordship said, the task of expounding a constitution is crucially different from that of construing a statute. A statute defines present right and obligation. A constitution, by contrast, is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power. It must therefore be capable of growth and development over time to meet new social, political, and historical realities, often unimagined by its framers. The judiciary is the guardian of the Constitution and must, in interpreting its provisions, bear these considerations in mind. Your Lordship, from these authorities, it is obvious that in interpreting Section 36 sub 3 of the Constitution, your Lordship must view that provision and the document itself as organic, as a living document, which must grow with the times and the realities, the social realities we are we're presently in. And Your Lordship, what is the key word in that provision? Place. Rather, my Lord, public. That is the key word in that provision. If you read it, it says judgment and proceedings will be conducted in public. There is no qualification of the word public. It is now left to the courts to define what the word public means. Your Lordship, there was a time public meant the public square, not even a building. For you to say something was public, you had to go in the middle of the market. It evolved to a building. You could have public buildings. But now, the internet is part of the public. Your Lordship, I'm sitting in my office right now. My door is shut. I'm alone. Ordinarily, it is private. But because I am on the internet via Zoom, I can see 146 participants. They are seeing me. They can see whatever I'm doing. I cannot afford to use indecent language. I cannot afford to dress indecently. If I say certain things here, I can be charged for defamation because I am no more in a private place. I'm on the internet. I'm in a public place. And it's my submission that insofar as the public can have access, insofar as the public can have access to the court proceedings by the internet media, then such proceedings satisfy the requirement of publicity under section 36(3) of the Constitution. So, Lordship, I go further to add that, and I make bold to say this, there is hardly any courtroom that can even entertain as much public spectators as the internet these days. We all practice. How many courts in the FCT can seat 100 litigants or spectators? But we are here, 148 of us. Conveniently, there is nothing more public than this. And it's my view, with all humility, that the constitutional provision has been satisfied. We are used to lampooning the legislature. We say, oh, the legislature, inelegant drafting all the time. But if there is one provision in the Constitution where they have done well, the drafters of the 1999 Constitution, and which you should commend them on, it is their deliberate use of the word public without adding any qualifying word. They just said public. They did not say public building. It was deliberate. They looked futuristic. Because what is public today may not be public tomorrow. Or the scope of public today may widen tomorrow. And they are giving the judiciary that opportunity to define that word public. Now, one of the rules of interpretation is that the judge does not make the law. It doesn't add to it. Most of the arguments against my proposition are to the effect that, oh, public must be a building, a place. You are adding to the law. If you read section 36(3), you will not find public building or public place. All it says is public. Finish. And insofar as we agree that the internet is public, then I submit that it qualifies, virtual proceedings qualifies or meets up with the standard set out in section 36 of section 3 of the Constitution. I quickly move forward to an analogy talking about the Constitution living. Look at section 37 of the Constitution. It talks about rights to privacy. In 1999, all we had were landlines, and it says, oh, the telephone conversation is private. In 2001, 2 years after the Constitution was drafted, we had GSM, mobile. Fast forward to 2014, you make calls by apps now, WhatsApp, Skype, BlackBerry. Would you say that because in 1999, we only had landlines in Nigeria, your right to privacy with regard to your WhatsApp calls can be breached? No. That right still extends to any mode of communication. That is how the Constitution should be construed. It must grow. And I urge your Lordship to follow that construction in the decision of this court. Dr. Zion SN was kind enough to raise one of the major concerns, Section 266 of the ACTA, which says the accused person must be in court for the purpose of trial. We are taught that in constrained statutes, we should look at the mischief behind the promulgation of that provision. The presence of an accused person was first guaranteed at the trial, was first guaranteed over 800 years ago in the Magna Carta 1215. You cannot be tried behind your back so that you can see what is going on in the proceeding. That is the essence. So that people will give evidence, you can hear what they're saying about you, can see the proceeding. If the accused person is in Kuje and he can see the proceedings, he can see the witnesses, he can see the judge, he can hear the argument of the prosecution, has the proceedings not satisfied the rationale? So in my humble opinion, Section 266 of ACTA, if interpreted in such a way as to take care of the mischief, virtual proceedings will not in any way hamper that mischief or cause that mischief. Other points, sitting in chambers, territorial jurisdiction, and what have you, all of these are settled by the same constitution itself. If you look at Section 259 of the Constitution empowers the chief judge of the court to make rules as to practice and procedure. Now, there are several authorities that have said this by virtue of Section 259 of the Constitution, the rules made by my Lord CJ or the practice directions have constitutional flavor. Now, looking at Order 52, 1 and 2 of the High Court Civil Procedure Rule, it empowers the CJ to determine where the court will sit. It is within its discretion as the CJ. If the court says the court can sit via Zoom today, then by virtue of Section 259 of the Constitution, my Lord the CJ has acted within his powers. And that is what Section 259 guarantees or Constitution guarantees. Now, my Lord, there is this concern, territorial jurisdiction, and a judge sits from outside the state and all of that. We all know that even when it comes to Zoom, we have IP addresses tied to a physical location. And thankfully, the NGC guidelines have answered all of this. The guidelines say the judge will still sit in his courtroom.
Let us take your time is up, sir.
Thank you very much. In conclusion,
yes, sir.
Thank you so much, Mimi. In conclusion, I urge your Lordship to find and hold that there is nothing unconstitutional about virtual proceedings. If your Lordship is to interpret the Constitution broadly, as admonished by the Supreme Court, your Lordship will uphold my argument. I humbly urge the court. Thank you.
Thank you very much, Lenesi. Please, may I invite to the microphone. I see the Lenesi CJ giving a hand clap over there. May I now invite to the microphone Mr. J.S. Okutekwa, SAN, for his submissions, please.
Thank you, Miss Moderator. Let me start by acknowledging the presence of my Lord, the Honorable the Chief Judge, my Lord, Honorable Justice H.B. Yusuf, and the presiding judge between me and Kehinde Ogunwumiji, Esquire, SAN, to decide these very knotty issues of constitutional validity and legality of virtual court proceeding. Let me acknowledge our leader, Chief Agwomolo, and Dr. Zion, and the rest of us on this panel. I didn't expect anything less from Kehinde than what he has done, because he has always been a proponent of an advanced argument, even in the face of constitutional provision, that we need to do what we need to do for people to benefit from legal knowledge. But unfortunately, the ground norms of Nigeria is the Constitution. And Section 1, subsection 1 says, the Constitution is supreme, and everything must be done in accordance with the provisions of the Constitution. And subsection 3 of section 1 says, if any law is inconsistent with the provisions of the Constitution, that law, including practice direction, is void to the extent of inconsistency. My learned brother, Kayode Ogunmi, Esquire, had struggled with respect, but in vain, to convince that visual court proceedings, particularly as relate to criminal trial, is constitutional. And the view is that we are on internet and everybody is hooked to it. With respect, this internet webinar conference is not open to the public within the context of the meaning of section 36, subsection 4 of the Constitution. You can only access this webinar if you are given access to it. Therefore, within the definition of public hearing, within a reasonable hearing, within a reasonable time, within the public, as defined by section 36, subsection section 6 of the Constitution, it is only the public that have access to the webinar or visual court proceeding that can access it. Now, that is not the case when you are sitting in the open court within the four walls of our court, because everyone can come to court without being turned back. And there are authorities of what constitutes public place and public hearing, and is not new. Supreme Court in 2007, in a Dibu against the state, 2007, 13 Nigerian Weekly Law Report, part 1051, page 306. The Supreme Court said the chamber of a judge, even if it is open for everyone to come in, is not a public place within the meaning of section 36, subsection 4 of the Constitution. And I have the privilege of being the one that argued that matter from trial court to the Supreme Court. What happened there was the learned trial judge took the plea of accused person in his chamber. And notwithstanding that I was a lawyer to the accused person, I drew his lordship's attention to the point that he couldn't do so because the Constitution does not envisage that the chamber of a judge is a public place, notwithstanding that his lordship of blessed memory, A.J. Kongbe, opened his chambers to everyone to come. The Supreme Court, in the final analysis, declared the proceeding null and void because that trial in the chambers of the judge, even though the door was open to anyone who wants to come in, was not a public place within the meaning of the provisions of the law. Again, in Nigeria Arab Bank Limited versus Barry Engineering Nigeria Limited, 1995, 8th Nigeria Weekly Law Report, part 413, page 257, the Supreme Court again said the chamber of a judge, even if open to the public, is not a public within the meaning of that definition. So, with these authorities of the Supreme Court on the point, the argument of my learned friend with respect of internet being a public place, everybody can access it, everyone can hear it, it paved into an idle argument with respect to him, that unless we convince the Supreme Court of the definition of public place given to section 36 of section 1 to overrule themselves, the authorities are that public place means the court hall where the judge, the judex is expected to sit. Therefore, internet facility is not a public place within the meaning of section 36, subsection 4 of the Constitution. Now, another issue is jurisdictional conflict. Now, there are 36 states of the Federation. When a judge is to sit, court buildings are located to them and courtrooms are located to them. They come in, they knock the door, and we stand up for them because that is the court, and then they sit and proceedings are conducted. Now, where will be the court hall in this proceeding? The practice direction says his lordship can sit in his court. So my question is, does visual court proceeding in the manner being advocated mean that a judge of FCT High Court can sit in Ogun State using internet and conduct proceeding if he's with his wig and gown? My answer is no. So my submission, therefore, is that the National Assembly should be commended for embarking on constitutional amendment to give teeth to this laudable initiative of hearing cases on virtual court proceeding. My learned friend Bolaji had identified a few things, obstacles. Dr. Ezeon talked about doctrine of necessity as part of the reasons why we must embark upon this. Doctrine of necessity with respect to Dr. Ezeon and all of those who hold his view is not a doctrine in a constitutional democracy. They were doctrines that were propounded as a result of military coup or extraordinary forces that indeed makes it practically impossible to do what it needed to be done. And so they needed to give legitimacy to the government that came into being by illegal means, so as to not to damage whatever contract and what have you that have been entered. So my submission, therefore, is that in view of the authorities of our court, the Supreme Court in particular, and the fact that practice direction with respect is an inferior piece of legislation compared to the law made by the National Assembly, need to have a constitutional backing for us to rely on it. My learned friend made reference to Section 259 of the Constitution. When you look at that provision, it says subject to an act of National Assembly. Subject to an act of National Assembly. And we all know what the word subject to means, which means if there is any other law other than this one, this law is subordinated to it. This law must pay fidelity to it. This law must show obedience to it. So practice direction is even subject to the act of National Assembly. And if that is being the case, then what do you need to do? Because there is a provision in our Administration of Criminal Justice Act that require mandatory that an accused person must be brought to court. And my learned friend, Moses Ebute, had dealt with the issue in admirable fashion, whether the suspension of criminal trial in paragraph 8 of the practice direction eminently issued by the Honorable the Chief Judge of FCT is not in direct conflict with Section 266 of the Administration of Criminal Justice Act, read together with Section 36, subsection 4 of that law, as far as criminal trial is concerned. So even in Section 36, subsection 1, in civil proceeding, in the determination of one's civil rights and obligation, a person is entitled to fair hearing within a reasonable time so as to ensure independence and impartiality. Somebody has spoken about internet hacking the Yahoo board. Are we going to get independence and impartiality of proceedings? How will the judicial officer sign the proceedings of virtual court proceedings? Because a judge must sign and date every proceeding. Will he be signing on the internet? How is he going to do it? It's no longer going to be in longhand. How is he going to do it? We need to have law of how proceedings are to be signed, judgment to be delivered and to be dated, and accused need to be in court. So with respect, laudable as this idea is, we require constitutional amendment to make it illegal. Otherwise, it may suffer the kind of what the provision of Section 397 subsection 96 subsection 7 of Administration of Criminal Justice Act suffer when the matter got to the Supreme Court. And I'm sure their lordships sitting down there when they take on the gap of judicial officers, not sitting in the panel of webinar with us now, will have the spirit of Judex enter into them to interpret the law without fear, favor, affection, or ill will. And rather than giving us this kind of hurdle to follow, let the lawmaker meet, let the national judicial, the judicial officers have a position, the bar have a position, go to the National Assembly, let's plug the whole loophole and let everything be done in accordance with the law. Not the ad hoc kind of arrangement we are doing because emergency has come. This emergency will still be there, they will come, but we need to think beyond today rather than providing ad hoc arrangement every time we have ad hoc issues and which may not last the test of time. So if you ask me, therefore, apart from other disadvantages that time will not allow me to talk about, and my learned friend Bolaji has talked about, even the quality of advocacy is going to dwindle in geometrical proportion, because if young lawyers are no longer allowed to follow us to court, that is where some of us learn the road. Today now you say, only one lawyer goes to court, you are going to face astronomical unemployment because we no longer need junior lawyer to follow us to court. As a senior advocate, I just need one lawyer. And once he follows me to court, that's all. The rest, 35 or the rest, can then go to farm in the village. So in taking a decision, looking for a solution for one problem, let us not also create another problem for the legal profession. So speaking for myself, therefore, I will urge my lords, or the Honorable the presiding judge, my Lord Justice Affair, to affirm and in his characteristic manner of a judicial officer of impeccable character, to hold that practice direction that encourages virtual court proceedings outside of the provisions of our law is unconstitutional. If he makes that pronouncement, heavens will not fall. It has never fallen and it will not fall. So I urge my Lord to do so in the interest of justice. Notwithstanding the submission of my learned friend, Kawede Midi, Esquire, SAN. God bless you for listening to me.
Thank you, learned senior advocate, Mr. J.S. Okutefa. I stand in awe of the both formidable arguments on both sides this afternoon. With the kind permission of my Lord the CJ, may I most humbly and respectfully hand over proceedings to Honorable Justice Peter Afen to take his ruling, sir. My Lord, over to you, please. My Lord, Honorable Justice Afen. Thank you, sir.
I'll be with you shortly.
Well, the court is in session. Let me not come in.
Well, thank you very much. Because of time constraints, I would have wanted to, in my characteristic manner, pose a few questions to counsel as they were making their arguments. But that opportunity is lost. And that, for me, is the most interesting part of proceedings when I am presiding. Let me say that this ruling is consequent upon a preliminary objection raised by Leonard J.S. Okutepa, senior advocate of Nigeria, against Kehinde Ogumumiju, senior advocate of Nigeria.
Very formidable argument before, yes, without even considering.
The parties herein are senior advocates of Nigeria applying their trade within the jurisdiction of this honorable court. And quite understandably, they are appearing pro se. Now, in the wake of the lockdown of the Federal Capital Territory to combat the dreaded COVID-19, the Honorable, the Chief Judge of the FCT, issued practice directions which inter alia allowed for the conduct of virtual proceedings. Whilst the validity of that COVID-19 practice direction is not in issue, Leonard J.S. Okutepa has argued that that provision of Section 9 offends Section 36, bracket 1, 3, and 4 of the Constitution of the Federal Republic of Nigeria, 1999. He has premised his argument on the fact that virtual proceedings do not qualify as a public place within the intendment, the meaning and intendment of the Constitution, in that you need to be invited before you can participate in the proceedings. Reference was made to the case of Edibo and the state, citation supplied, wherein the word public was construed by the Supreme Court of Nigeria. He further argued that the doctrine of necessity is not applicable and that the practice directions offend Section 366 of the Administration of Criminal Justice Act, which has provided for the presence of the accused person. He contended that there is need to amend the Constitution in order to provide for virtual hearing rather than the ad hoc provisions in the COVID-19 practice directions. He has urged me to strike down Section 9 of the COVID-19 practice directions to 2020 for being inconsistent with the Constitution and other enabling laws, making reference to Section 1(1) of the Constitution, which emphasizes the supremacy of the Constitution and acts or laws which are superior norms to the rules of court. Now, the reaction of Kehinde Ogunwumiju, senior advocate of Nigeria, is that the Constitution is not to be interpreted like any other document, but that it is an organic document that must be interpreted in the light of the times in which the court is called upon to undertake the interpretation. Reference was made to the cases of Obi versus Mbakwe and Marwa and Inyako on the need for the court to treat the Constitution as an organic document and give it a broad rather than a narrow meaning. He contended that the meaning of public has evolved over time, such that the internet is now within the definition of what is public. He buttressed the argument by pointing out that we have over 150 participants in this webinar, which has accommodated more persons or members of the public, much more than any conventional courtroom can accommodate. And that the provisions of Section 36(3) and 4 did not qualify the word public with any other adjectives, and it must be given its plain natural meaning. He argued that the presence of the accused person within Section 266 of the Administration of Criminal Justice Act is merely to ensure that the accused is not tried behind his back, and that the accused presence in the virtual proceedings at the correctional center would satisfy that requirement. He also talked about Section 259 of the Constitution, which empowered the Honorable the CJ to make these practice directions, and also where the court can sit per time. I have been urged to hold that there is no need or necessity to amend the Constitution, but to breathe life onto the meaning of the unqualified use of public within the meaning and intendment of Section 36(3) and 4. Now, that's a summary of the arguments ably canvassed by learned counsel on both sides of the divide. I make reference to Section 36(1), having given a careful and insightful consideration to these arguments, and that whereas subsection 1 of Section 36 provide for the plenitude of the right to fair hearing in both criminal and civil proceedings, and for trial to be conducted within a reasonable time by a tribunal that is established in such a manner as would guarantee the independence and impartiality. Subsections 3 and 4 provide that hearing shall be held in public within a reasonable time by a court or tribunal. I pause here to say that in respect of criminal proceedings, the proviso to subsection 4 of section 36 has already provided for circumstances in which members of the public may be excluded, inter alia, on account or in the interest of defense, public safety, public order, public morality, etc. That is to say that where a criminal proceeding is conducted without the public, quote and unquote, being present or being excluded, it would seem that in respect of criminal proceedings, section 34 bracket A, that is the proviso, seems to have taken care of that eventuality. I pause to say that because the learned J.S. Okutekpa, Senior Advocates of Nigeria, pointedly referred to subsection 4 of section 36 without reference to the proceedings, sorry, to the proviso. And I have been denied the benefit of his arguments in respect of that proviso relative to what we are doing now. Now, what is of immediate relevance in this preliminary objection, as it seems to me, is the meaning of the phrase "in public" in subsection 3 and 4 of section 36. Now, to the best of my knowledge, neither the Court of Appeal nor the Supreme Court of Nigeria has had the opportunity of construing these phrases in relation to virtual proceedings. This is therefore an uncharted territory, as it were. Now, the cases upon which learned JSO has heavily relied relate to proceedings conducted or judgments delivered in chambers, which was held not to constitute a hearing in public and therefore unconstitutional, null, and void. For instance, a Debo and the state plea was taken in chambers. In Menekaya and Menekaya, as well as Oviasu and Oviasu, which were matrimonial proceedings for dissolution of marriage, hearing took place in chambers, contrary to the express provisions of sections 103, bracket 1 and 2 of the Matrimonial Causes Act of 1970. See also the case of Nigeria Arab Bank and Barry Engineering Nigeria Limited, where hearing was conducted in open court, but judgment was delivered in chambers. Now, the rationale for these decisions, as Oguagu JSC put it in a Debo and the state, is that a judge's chambers is not and cannot be equated to a hall in a building that is used for formal meetings. As a matter of fact, the chambers can also be defined as or equated with a private bedroom or private room. Even in Black's Law Dictionary, 7th edition at page 224, a judge's chambers is defined as the private room or office of a judge. Close the quote. In other words, the chambers of a judge is not a public place in which the general public have unfettered right of ingress and egress as of right, except on invitation by or with permission by the judge. See the dictum of Ogundare JSC, Nigeria Arab Bank and Barry Engineering Limited. Now, it cannot escape notice that the language employed in section 36, 3 and 4 of the Constitution is in public, not open court, as in section 103, 1 and 2 of the Matrimonial Causes Act of 1970. The law is well settled that a case is merely an authority for what it decides. This is, of course, a notorious proposition for which the citation of authorities is needless. But for reasons of completeness, I will refer to the decision of the Supreme Court in Insefik and Muna, per Muhammad JSC. Citations are supplied. And even though section 36, 3 and 4 was considered in the said decisions, the phrase "in public" was not construed at large, but in the light of the peculiar facts of the cases that came before the court. What those cases decided was or is that conducting hearing or delivering judgment in judges' chambers does not amount to a hearing in public. Nothing more, nothing less, nothing else. It seems to me, therefore, that the cases relied upon by the defendant objector are not of much assistance in determining the constitutionality vel non of virtual proceedings. Indeed, to assume that virtual proceedings are unconstitutional merely because proceedings conducted in chambers have been held to be unconstitutional would be to commit the fallacy of false cause. After all, it is cliché that each case must be treated on its own merits. And as Lord Stern once said, in law, context is everything. See Regina and Secretary of State for Home Department, ex parte Dali, citation supplied. Now, the validity of the practice direction is not an issue, but as we all know, practice directions are merely intended to be supplemental protocols to the rules of criminal and civil procedure in courts, written explanations or guidelines on how to proceed in a particular case. See Olafemi and others and Ayo. From a practical perspective, both rules of court and practice directions are designed to achieve the same object and attain the same objective, namely regulating the practice and procedure of the courts. But a practice direction is not coterminous with rules of court, which have greater authority or stand on a higher pedestal. See on this the cases of Buhari and INEC and Abubakar and Yaradua. Also the case of University of Lagos and Maigoro. Now, remote hearing or virtual proceedings entail the conduct of legal proceedings, whether wholly or in part, by the use of live video or audio links, whereby parties and their counsel, as well as interested members of the public, take part in the proceedings via telephone or video conferencing facilities without the necessity of physical attendance in the courtroom. The question I've been invited to resolve is whether virtual proceedings qualify as hearing in public within the meaning and intent of sections 36, 3, and 4 of the Constitution as amended. To my mind, the key to unlocking this puzzle lies in the meaning of the word public, which has been judicially defined in several decisions. Fortunately, in a Dibo and state to which learned counsel for learned J.S. Okutepa has heavily relied, His Lordship, Professor Nikki Toby, Justice of the Supreme Court, may God bless his legal soul, defined public as being available, quote, for the use of everyone without discrimination, close the quote, and that, quote, anything, gathering or audience which is not private is public, close the quote. Whilst it seemed to me obvious that a judge's chambers does not fit the above judicial definition of public, the relevant inquiry is whether a remote hearing or virtual proceeding is available for the use of everyone without discrimination, or can it be regarded as a private gathering or audience? I do not think so. I take the considered view that hearing in any platform, including remote hearing or virtual proceedings, to which members of the public have or are granted access without discrimination, qualify as a hearing in public within the meaning and intent of section 36, 3, and 4 of the Constitution of the Federal Republic of Nigeria as amended. In this regard, I take judicial notice of the practice of the court, which enjoin court registrars to give notice of the cost lists and access codes, links, or meeting IDs for remote hearings or virtual proceedings to the parties and their counsel, as well as publish same in the court's website. And interested members of the public are at liberty to join remote hearings to observe proceedings without discrimination, just as they are free to attend court proceedings in the courtroom without discrimination. I therefore entertain no reluctance whatsoever in affirming my agreement with the submissions of Kehinde Ogunwumiju, Senior Advocate of Nigeria, that the provisions of sections 36, 3, and 4 of the Constitution as amended are wide enough to accommodate remote hearing or virtual proceedings, which are open not only to the Nigerian public, to the entire wide world. I resist the temptation of saying that remote hearings even offer a wider opportunity than any courtroom in Nigeria could possibly accommodate. I also take judicial notice of the fact that Over 150 participants are hooked up and are watching me in these virtual proceedings. I pause to ask, what more can be more public? The mere fact that virtual proceedings are a novelty in Nigeria is certainly not a valid basis for developing any anxieties in this regard. To paraphrase the legendary Lord Denning, if we never do anything which has not been done before, nothing will change. The entire world will move on whilst the law remains the same. And that will be bad for both the world and the law. I have referenced the case of Parker and Parker. I hold, without any hesitation, that remote or virtual hearings are not unconstitutional, and accordingly record an order dismissing the preliminary objection raised by the defendant. Hearing shall proceed in the manner earlier scheduled without further assurance. There shall be no order as to cause.
As the court pleases.
Praise the Lord.
As the court pleases.
Praise the Lord.
My Lord, we are most grateful. We are most grateful for your welcome to that ruling.
My Lord,
I know that I speak for myself as much as I speak for all the participants that this session was very enlightening and educating. At this point, may I noticed, I presume that my Lord, the CJ at some point wanted to make some comments. I do not know if my Lord, the CJ wants to say anything at this point, sir.
It's with regard to two issues. One, the issue of doctrine of necessity, which was canvassed by the learned Mr. Izinho. This can perfectly come within the role of the Supreme Court as a policy court to look at the prevailing circumstances and then allude to that in exercising that power of its policy decision-making to embrace these technological development so that we can forge, even without constitutional development. That is that. Two, the issue of defendant being present in court throughout trial. We have already engaged service providers, and we had raised so many questions in this regard, and we were able to find solution. All you need to do is to find the relevant of highly potency, the service, the kind of internet within the prison or correctional service centers. Once you install the facilities there, in fact, I had the privilege of linking up to the discussions that was hosted by Olanife Akunyi SAN, and I had a series of arguments, even on the issue of locus in co. All you need to do is to have your laptop there, and then you link up all other persons involved, and even interested audiences, wherever, or spectators can listen, can watch, and then you get back to the courtroom, if any. You make your own submissions, still online. So the defendant, what is the rationale behind insisting that the defendant must be present all the time? It is simply because he should be able to listen to the evidence, and if there's anything incriminating, he will have the opportunity to debunk that. All right, apart from the physical appearance, not just for him to be cited. No, to give him the opportunity to listen to the evidence. And if there's any incriminating evidence, he can debunk it. Of course, the demeanor of the defendant too is material to the judge. All this could be available. We at one time wanted to install certain facilities at Kuje because we wanted to make the Kuje High Court absolutely criminal trial. We have 3 courts there, in fact 2 courts and about 6 chambers, all right, as we see in other climes. No judge has a single courtroom to himself in other developed climes. They have cluster of chambers with 2 courtrooms and then time apportion. If a lawyer is to come 2 o'clock, Judge A is sitting in court A, all right? And the moment he finishes, Judge B is coming in, he has given some lawyers time frame, and that within that time frame, cases are decided, and they move fast, all right? Because all interlocutory issues have been sorted out, it can go on the expectation of trial day to day. Unlike in our own client, people talk about trial day to day, whereupon in Nigeria, a judge has 50 cases on his docket. In the climb where you have day-to-day trial moving on, it's a scenario whereby all threshold issues have been exhausted. The judge can move on trial. In this scenario, when you're on top gear, somebody will deliberately raise an interlocutory issue to stall the smooth conduct of the proceedings. Unless all hands are put on deck for us to do the needful, we are not likely to attend that. But coming back conclusively, there is no how visual trial will offend either the provision of AJA as to the appearance of the defendant or infringe on the requirement as to public place because looking at the provision of section 36 of the Constitution, even without amendment, I maintain, in line with Ogunju Omiju submissions, that visual trial can proceed. In any case, the National Assembly, I think, is already on the second reading on the bill that is amending the Constitution. It has added additional provision to section 36, all right? And if there's any ills, is being remedied. But even without that, it is early. I mean, it is high time that the appellate court should see reason, not always wait for amendments before they can make pronouncements. As Ogunmiju said, the Constitution is organic. It is meant to extend and cover futuristic development at all times. It's purposeful interpretation that is required, and that can be achieved. And I hope the COVID-19 thing has now brought the motivations that will compel everybody, every facet of stakeholders. We, the analog, the BBC that is born before computers, that are still there, not willing to move to the digitalized world, are now being compelled, either from the bar or from the bench. People have to embrace this. It has come to stay. And I can tell you, the FCT is prepared, it's combat ready. It will move and throw the first stone to take decision along the line of trial and criminal matter. Let it go to the Court of Appeal. We are prepared to promote and stimulate changes in our jurisprudence. And that's how it should be. Thank you so much. Thank you.
Thank you very much, my Lord,
All right.
Honorable CJ. May I, at this juncture, with the kind permission of my Lord, the CJ, seek your permission to take a few questions from the participants on this webinar. My Lord, the CJ, do I have your permission, sir?
Go ahead, please.
Thank you, my Lord. Before we take the questions, may I most humbly and respectfully invite the Solicitor General and Permanent Secretary of the Federal Ministry of Justice, Mr. Akpata SAN, for his comments.
Hey.
Solicitor General, sir, can you hear me, please? Okay. Unmute yourself, Mr. Solicitor General. We can hear you.
Okay, please, what's the question? I'm just coming in for another meeting, from another meeting.
Oh, we apologize. We just gave you an opportunity to make your final comment. Okay, maybe I'll give you some minutes to put yourself together. May I read the first question from
your closing remark.
Mr. Solicitor General, can you hear me, sir?
I can hear you now.
Okay, sir. So I was saying that we gave you an opportunity to make final comments before we proceed to take questions from participants. Do you have any comments at this moment, or do I assign a question to you later on?
Oh, okay, maybe this is another opportunity for me to just, like I was discussing in my opening remarks, that the Ministry of Justice is essentially the largest chamber in Nigeria, and we are already working towards actualization of the practice direction. And in doing that one, we are presently doing the assessment of our ICT infrastructure. We're already setting up a virtual conference studios in the ministry. And we're also doing some assessment. We are discussing with the correctional services to expand their ICT in terms of prosecution. And also the needs assessment and capacity building of the state council is also being worked on now. And we are also discussing with by next week, we hope to have a virtual meeting with all the attorneys general of the attorney general will be taking the leadership in the discussion on the issues relating to this. Essentially, what I'm saying is that we are also engaging the National Assembly on the constitutional amendment to accommodate the practice directions. So these are the issues which I wanted to put in my opening speech, which I was not able because of some hitch in the webinar. So these are things I actually wanted to tell them that we are already in the process of putting things in place, everything in place to ensure the practicability and working together with the judiciary to ensure that things are done. Thank you very much.
Thank you very much, Leonard, Solicitor General and Permanent Secretary of the Federal Ministry of Justice, Mr. Apata SAN, for your contributions. And distinguished panelists, ladies and gentlemen, may I just proceed to take a few questions, maybe if you allow me, for each panelist. So we have the first question is from Mr. Jokari Gatsama, Senior Advocate of Nigeria. He has 3 questions, but I would seek his permission to take just one for now. The first question is, for my lords to succeed in the onerous task of justice dispensation henceforth, onerous dispensation of justice, there will be need to, oh God, I can't get that. Okay, fine, so I'll come back to that. It is in the public domain that the National Assembly is now considering a bill to provide a requisite legal backing for the virtual hearings in our courts. Have inputs from both the bench and the bar been put across to the National Assembly? I do not know if this is directed at, I don't know, can any of our panelists attempt to answer this?
Hello?
Hello, sir, we can hear you, sir. Milord, the Honorable CJ, sir.
Yes. Well, as to any input, the chairman Senate Committee on the Judiciary is a live bencher, and of course he has reached out to members of the bench and the bar for necessary input. And because I remember the last time we held NGC meeting, when the president of the NBA, along with other senior advocates who are members of the NGC, made a presentation of a memo in this regard. It was well accepted, and then a committee was set up, and which I was also a member, and we charted a course, and this was, the outcome of it was sent to the chairman of the Senate Committee on specifically on the issue of section 36 and other relevant statutes. So there is indeed an input on both sides of the divide, the bar and the bench. Hello? Are you with me? I don't know how this thing came.
Yes, thank you very much, the Honorable CJ. Hello, sir.
Hello?
Okay.
You heard my response.
Yes, my lord. We heard you, the Honorable CJ. Yes, sir. Thank you very much, sir. We appreciate it. May I now invite Baba Siwaju Awomolo, SAN, for his final comments? Baba Siwaju, sir.
It appears Baba Asiwaju is not around.
Okay, while we wait for him to take a shot at his timing, may I just, there's a question here from Max Ikongbe, and I think it is directed at, I would rather my Lord Honorable Justice H.B. Yusuf attempt answering that question. Said, looking at the time frame specified in Section 5 and considering the fact that many are still unable to move around freely, would the waiver on computation of time be further extended? Oh, he can't. I'm leaving questions now. My Lord, sir, can you hear me, sir?
Hello, Mimi.
Yes, sir. Yes, my Lord.
Yes, I can hear you.
Yes, my Lord. There's a question about the continuation of the waiver on computation provided for in our practice direction, sir. Is there a possibility?
Well, I have said in my presentation of the overview of the provisions of the practice direction that the waiver granted is predicated on the partial easing of the lockdown, which permits people now to move around within the Federal Capital Territory, and which enables all the courts to begin court business. So to that extent, if anybody or a council has processes to file or processes that have been filed or are about to be filed, is free to do that. Aside from that, if processes have been filed and you access our registry for the purpose of serving of such service of such processes on the opposing parties, you are at liberty to do it. So I do not think there's any further constraint. Why the time, the period between March and early April was excluded is because the courts were virtually unable to, do anything. Now we have commenced sittings. The registry is fully open, and we are receiving mails. We are receiving processes from litigants. And once you get into the registry, those who should effect services are our registrars and bailies of court, and they are available. So I do not see any need for any fear that could be entertained in that direction.
It's all right, my Lord. Thank you so much, Honorable Justice H.B. Yusuf. We appreciate. Now, permit me to go back to Baba Asiwaju. I understand he's back online now. Let's take his final comments.
Thank you very much. Let me appreciate my Lord, the Chief Judge of the Federal Capital Territory Court, for the privilege. And let me say that the judgment of my Lord Justice should be circulated so wide that and secondly, the FCT should create a pattern of that will anchor all the court, because the infrastructure is enormous, the amount is enormous. So I'm going to encourage my Lord the Chief to devote a substantial sum of money to strengthen the infrastructure and training the staff, because it's very important to have efficient staff, responsible staff, who will not compromise the integrity of the system. So I want to believe that ICT has come to stay, and forward ever, backward never. Thank you very much, sir.
Thank you very much, Baba Asiwaju, for your final comments that we appreciate. We are grateful. We thank you for honoring us this afternoon. So our next question is not directed at any particular person. I beg your pardon, just a moment. Let me read these things out. So with the effect, the first question is, with the effect of the lockdown, can there be a fast track for criminal cases where the defendants are in custody? That question comes in from Mr. Umukuru. I do not know if my Lord Honorable Justice Peter Afen is willing to take that question for us.
Can you say it again, please?
With the effect of the lockdown, can there be a fast track for criminal cases where the defendants are in custody?
Maybe I should hazard an answer, but if you look at the practice directions, if you look at the practice directions, we are mindful of not bringing these inmates to the court so that coming and going from the court does not become an avenue for catalyzing the spread of COVID-19. The truth is the entire world is still grappling with it. That's why we are hoping that we'll be able to make incremental advances. For instance, if the provision my Lord is talking about in the prisons, the facilities in the prison and the efforts the Solicitor General and the Attorney General are putting in place, if we can make some ad hoc arrangements to deal with that, yes, that will be possible. But as things stand now, we are dealing with lockdown, the advisories, the executive orders, the executive which wields the physical powers that will restrain people have said, don't bring inmates to the courts. I don't know what they expect the courts to be able to do now. Whilst we appreciate that some people are in prison, and let me tell you, it doesn't give us any joy to see our citizens, our brothers and sisters languishing in jail. It is the circumstances in which we have found ourselves. So let us try what we're doing. Let's get cracking, as it were. Let's hit the ground running. I talked about there being room to modify the practice directions. Naturally, if things do improve and we are able to put in place a few things, we will definitely give the required attention to those who are in detention or in custody. But as it is now, to say let us fast track the hearing of cases in which inmates are there would mean we will have to transport them to the courts against the advisories that we all have. Don't you want us to remain alive to be able to do the very onerous task that is entrusted to us? Thank you very much.
Thank you, my Lord, Honorable Justice Peter Afen. At this point, virtually all the questions sent in have been answered one way or the other during the course of our various presentations. So I will just proceed to call on Dr. Alex Zion, SAN, for his final comments. Doctor, please unmute your microphone.
I thank my Lord, the Honorable Chief Judge of the FCT. I don't want to use the same judicial activism, but for that remark he made on the issue of doctrine of necessity, that the Supreme Court, because this interim between now and when the National Assembly will make the amendment, that doctrine become imperative. And I just want to allow myself that in Yeso and Peter side, 2016, the Supreme Court invoked the doctrine of necessity in Lacomi's case. That is part 1517. If you read it, you will see where the issue relates to governorship election tribunal for a state, not in a state. the proceeding being held in Abuja, contrary to the provision of the Constitution, which was decided in the case I did earlier, 13 years earlier, in Ibori and Agbe, that the data tribunal cannot be brought to Abuja. Then the Supreme Court said the practice direction of the president was in order because of the exigencies of the security challenge we had in hand. So if you read that decision, Lakobi was cited with relish by their lordship. So just to concur with my lord that I'm very sure that in the interim measure, if there's anybody, because certainly there may be there has to be challenge. There's no how about that. You can't rule it out because the losers will always go to court and on appeal is normal. So that's the beauty. But I'm very sure that this doctrine will sail in any day, any time. I thank you again.
Thank you, Leonard SAN, for that succinct comment on the webinar. May I now proceed to invite to the microphone Leonard Sik Okutekwa, JS Okutekwa, I beg your pardon, JS Okutekwa SAN for his final comments, please.
Well,
please don't go on appeal.
Let me. I do not know what the Honorable Chief Judge has said, but from the commentary that I have been receiving, let me salute the judicial sagacities of my Lord Honorable Justice Peter Afen for this decision. I hope that this purposeful and positive judgment which he has delivered will be made available to us, and it will spread not only down, but also to the upper echelons of our courts, so that some of the things that some of us have been complaining about in the time past that are constituting judicial roadblock to justice in Nigeria will be effectively put to rest in the course of this kind of COVID-19 that are now giving us opportunity to think beyond restricting ourselves to the letters and the spirit of the law. For instance, the doctrine of law that is gaining currency now, that is certified through copy of public document should be tendered by the maker of the document, has now been made to look very, very idle in the light of this erudite and very purposeful judicial exposition by no less a person than His Lordship Honorable Justice Peter Afen. And I think that the judiciary should, without sounding to patronize him, I lost in the argument, but my Lord said I should go on appeal. No, I'm not. Yesterday I told Kennedy Ogumiji, I told Kennedy Ogumiji to take the other side, and he has always been doing so. I have always been advocating that the judiciary is the last hope of the common man. Now that no roadblock is put on our way, I wish that my Lord was sitting as a judicial officer, so that this judgment can then be referred to as a decision of His Lordship to have the stamp of authority at the Court of Appeal and the Supreme Court. So I call on the bar to also take on this kind of matter. We'll go to Supreme Court and then have a decision to enable us do justice in this country. Because over the years, I have always been of the view that the judgments of our court with respect seem to encourage injustice than the justice that we deserve. Now that justice has been opened in the theater of operation, I'm happy that my Lord has delivered judgment this afternoon. God bless you, my Lord. I didn't expect anything less than that because I know I was going to get it the way I got it.
Thank you. Thank you. Thank you. Thank you.
Thank you, Leonard Senior Advocate, the very erudite Leonard Senior Advocate, for your submissions. It's always exciting listening to you on all fronts. At this point, may I please invite Mr. Akende Ogunwumiju SAN for his final comments.
Thank you very much, Mimi. May I humbly express my appreciation.
Mr. Ogunwumiju SAN, sir.
My Lord. Thank you very much, Mimi. Can you hear me?
Yes, sir. We can hear you, sir.
Thank you very much, Mimi. May I humbly express my appreciation to
Yes, we can hear you. Please proceed.
Thank you. My humble express my appreciation to the organizers of this webinar. I also thank my Lord Justice Appen for the favorable ruling. I thank your Lordship. A lot has been said about the attempt to amend the Constitution in order to legitimize virtual proceedings, virtual court proceedings. This, in my view, aside from argument, is a positive step forward. But we all know the hazards of constitutional amendment. It usually takes a lot of time. You need, apart from concurrence of two national houses in the National Assembly, you need concurrence of 2/3 of the state houses of assembly, as well as the presidential assent. Usually, constitutional amendments are lumped together with, are done, with several other amendments of other provisions in the Constitution. And usually, even if one particular provision is desirable by everybody, certain provisions will be controversial, and this usually delays the passage of this amendment. So what are we to do till an amendment is finalized? We need to think purposefully, and that is why I commend the decision of my Lord. We cannot wait until the amendment comes to reality. It may take a year, it may take 2 years, for all we know. Another angle to it is, in order to save us from what happened with regard to the recent decision in the Ontario Okali case, the provision of the ACTA and all that, the Attorney General of the Federation can actually approach the Supreme Court for an interpretation of that provision and invite amicus curiae, invite attorneys general from the other 36 states. And the Supreme Court can give a decision early in time so that we don't start proceedings, virtual proceedings, only for us to get to get to the Supreme Court 2 years down the line or 1 year down the line, and then everything is thrown out. So that said, I want to wish every other person a very splendid afternoon. Thank you very much.
Thank you, Leonard, Senior Advocate. We appreciate the conversations this afternoon. May I invite Mr. Enenche Eleojo for his final comments on anything from the registry.
Okay, thank you very much, Mimi, for this opportunity to take a bite at the cherry again. Like I said when I spoke earlier, we are going through very extraordinary times, and we need extraordinary measures such as this. All we can do from here is to seek your indulgence, to bear with us. Sometimes when you come in, there may be some inconveniences you will have to go through, but we need to understand that those inconveniences are for the greater good, so that as soon as we come out of this, we'll be healthy, to attend to our normal court businesses again. Thank you very much, Mimi.
Thank you very much. We appreciate you. Thank you for your time. We appreciate. May I call on Mr. Moses Alfred Ebute for his final comments, if you have any?
Hello, can you hear me?
Yes, sir, we can hear you, sir.
All right. I wish to sincerely thank the committee that organized this webinar, and thank my Lord, the CGA, for the initiative of this passage direction, without which there wouldn't have been this webinar in the first place. More powers to his elbows and to his lieutenants there. And I want to thank Honorable Justice Affen for this wonderful ruling he just gave. It's very sound and learned. And I'm very sure that if he's able to get to the judgment is able to get to the Senate Committee on Judiciary, they may have to abandon that proposed amendment. Thank you very much. I'm grateful for inviting me to the forum.
Thank you, Mr. Moses Ebute, for your contributions. May I call the last but not the least, Mr. Lukman Bolaji for his final comments, please.
Thank you, Ms. Mimi.
Mr. Lukman.
Thank you. I want to appreciate once again the opportunity to learn directly from both Milots and the learned senior advocates present and other panelists. I want to use this opportunity to urge my Lord the CJ to invoke the provisions of paragraph 13 of the practice direction to incorporate the NJC's guidelines by reference. And that is what the National Industrial Court did. So in doing that, the measures that the FCTI court is taking to protect court users will be open and known to the public as a whole. So I want to implore Melo to incorporate the guideline of the NJC into this practice direction. Thank you.
Thank you, Mr. Bolaji. We are grateful for your contributions. Milord, the Honorable Chief Judge of the Federal Capital Territory, Milords here present, senior advocates of Nigeria here present, distinguished participants, may I at this juncture seek most respectfully and humbly the permission of Milord, the Honorable CJ, to invite the alternate chairperson of the Committee on Legal Practice of the Nigeria Bar Association Abuja branch, Mr. Bulama, for his vote of thanks.
Wow.
Alternate chairman, sir.
I thought we don't go.
Okay. Milord, I have just, I beg your pardon, I have just been informed that the alternate chair is not online. May I most respectfully and humbly invite the chairman of the Nigeria Bar Association Abuja branch, Mr. Abimbola Kayode, to give the votes of thanks. Mr. Chairman, sir, please, can you please unmute your microphone?
Thank you, Mimi. You can hear me? Mimi, can you hear me?
Yes.
Okay.
Yes, sir, Mr. Chairman, we can hear you, sir.
Okay, thank you very much. May I, on behalf of the Nigerian Bar Association Abuja branch, thank my Lord, the Honorable the Chief Judge of FCT, my Lord, Honorable Justice Peter Afen, my Lord, Honorable Justice H.B. Seni Baba. May I thank the learned senior advocates, Ashiwaju Awomolo, Alex Izinyo SCN, J.S. Okutepa SCN, Mr. Tayo Akpata SCN, my colleagues there, Alfred Bute Esquire, and all other panelists for doing justice to the topic for discussion today. It is my sincere prayer that we have the opportunity to have further discussions, even as we progress in using the practice direction. Once again, on behalf of the Nigerian Bar Association, I thank you all, and God bless.
Thank you, the indefatigable chairman of the Nigeria Bar Association Abuja branch. Milord, the Honorable CJ, may I please crave your indulgence to declare this session closed, sir. Over to you, Milord, the CJ, sir.
Thank you so much. Thank you so much. It is indeed a pleasure that by the grace of God, we have been able to go through the agenda as designed by the organizers, and certainly it has been very exciting. It has brought together family members who have deliberated on issue of common concern, and we believe the conclusions that we have arrived at will chart the course for greater height within the circle of justice delivery in Nigeria, which of course every component stakeholder has participated and contributed immensely. That is the bar, the bench, and perhaps other participants as spectators. So we are grateful for this very opportunity by the host. May your pocket not dry, and your intellect will continue to get sharpened, and Nigeria will belong to the club of nations that have embraced technology within the realm of justice delivery in Nigeria. I thank you so much. May the Lord take you back to your respective destination safely, even as you are staying in your houses. Thank you.
Thank you, my Lord, the Honorable CJ. Thank you, my Lords here present. Thank you, learned senior advocates here present. Thank you, senior members of the bar here present. Thank you, colleagues. Thank you, ladies and gentlemen. It has been an honor moderating this session. My name remains Mimi Ayua, and I look forward to seeing you subsequently on some other time. It's good afternoon from here.
Thank you, Mimi.